Thank you, Jonathan. Now I'm going to talk to you today about the Golden Ocean Group Limited and Salgacore Mining Industries Pvt Limited and another case, which considers whether it is arguable that an email chain could constitute an enforceable guarantee and legally binding contract. But before I tackle the judgment and implications of the case, I'm really going to go back to basics and remind you of the key components which are held under English law to be necessary to constitute a legally binding and enforceable contract, as this is a key issue under the case. Now, for those of you that didn't have the pleasure of law school, or for those of you for which it is just a dim and distant memory, the elements required for the creation of a contract are offer, which is said to be the expression of willingness to contract on specified terms, made with the intention, actual or apparent, that it is to become binding as soon as it is accepted by the person to whom it is addressed, acceptance with the intention to create legal relations, which is said to be a final and unqualified expression of assent to the terms of the offer, and consideration, which is said to be something of value. Now, traditionally, when parties do not intend to be legally bound until they formally sign a contract, they will use the term subject to contract and will plaster it over negotiation documents such as emails, letters of intent, and term sheets, which is meant to indicate that there has not been acceptance and therefore that there is not an intention to create legal relations. With this component of acceptance said to be missing, the premise is that a legally enforceable contract does not exist. In other words, the general legal proposition and rule is that where an agreement or negotiation is said to be subject to contract, there is no binding contract until there has been an exchange of contracts whereupon the documents are signed and traditionally dated. Now, the rule obviously enables either party to renege on a concluded agreement without impunity. This has been described as a social and moral blot on our law, and indeed the courts have, in certain strong and exceptional circumstances, been prepared to rebut the presumption that the word subject to contract is evidence that a legally binding contract is not in place. And I will touch on this later in the webinar. Now, although I've just said that the courts are prepared to infer the existence of a legally binding contract despite the use of the term subject to contract in the course of pre-contract negotiations, it is only in strong and exceptional cases that they will do so. Now, I don't want to detract from the Golden Ocean case, but it is worth reflecting on a couple of such examples and the circumstances which have resulted in the presumption being rebutted. Now, I'm going to take you on a very quick canter through these circumstances rather than dwell in depth on the facts of the specific cases. Where parties are said to act in a way that is inconsistent with the subject to contract label is one such circumstance where a legally enforceable contract can be said to be enforced. So, for example, beginning work on an interim basis, starting to perform obligations set out in negotiation documents, which is accepted by the other party, infers the existence of a contract irrespective of how it may be headed. In the Rugby Group Limited case referred to on the slide, Proforce was an employment agency who entered into an agreement with the Rugby Group Limited, under which Proforce was expressed to hold preferred supplier status. It was claimed by Proforce that despite the heading subject to contract in the parties' negotiation documents, the parties had acted in a way which was consistent with a binding agreement being enforced. Under the facts of this case, both parties had performed the matters specified in the pre-contractual documentation. Rugby Limited had purchased supplies from Proforce and had provided personnel to Proforce, for which Proforce had made monthly payments. So in summary, conduct can counteract the subject to contract label. It has also been held in the Michael Richards Properties Limited case, again full reference is up on the slide there for you, that where the heading subject to contract remains on the document in error, a legally binding contract is said to exist. So again, conduct and intent can counteract the subject to contract label. So now we come to the Golden Ocean case. By way of very brief background, the Golden Ocean case is a shipping case. Golden Ocean were the owners of a vessel which they offered to charter to Salgacore Mining Industries Now from here on in, I will be referring to Salga Core Mining Industries as SMI, as it is less of a mouthful. SMI agreed to enter into negotiations to charter the vessel on a 10-year contract through its nominee company, Trustworth Pte Limited. During January and February 2008, negotiations took place between Golden Ocean and Mr. Salga Core, acting on behalf of SMI and Trustworth. The negotiations were conducted over email, one of which contained the statement that Trustworth was being fully guaranteed by SMI. Negotiations appeared to conclude at the end of February 2008. A final contract was drawn up and circulated, but unhelpfully was not actually signed by the parties. In late 2009, which was the delivery date for the vessel, Trustworth and SMI refused to take delivery, stating that a binding contract and guarantee did not exist. Golden Ocean claimed that the repudiation caused it losses of around $54 million and claimed that sum against SMI under the guarantee. The defendant argued that there was no serious issue to be tried because the claimant could not demonstrate that its claim against the first defendant had a reasonable prospect of success on the basis that the guarantee was unenforceable under the Statute of Frauds 1677. Now, for those of you that are not familiar with the Statute of Frauds Act 1677, Section 4 states that no action shall be brought against the defendant upon any special promise to answer to the debt, default, or miscarriage of another person, unless the agreement upon which such action shall be brought is in writing and signed by the party charged therewith, or some other person thereunto him, by him lawfully authorized. Now, if you can get past the oldie English turn of phraseology in this section, it is in summary saying that a guarantee will only be enforceable if it is in writing and signed by the person making the guarantee. The defendants claimed, amongst other things, that the guarantee was unenforceable against them because it had not been signed by them. Now, the court stated that the spirit of the Statute of Frauds was concerned to see that guarantees could not be enforced if they were not embodied in an agreement made in writing. The court held that on a proper analysis of the email exchange, the policy behind the statute was in no way frustrated, and indeed it was said that it was good commercial sense and highly desirable that the law should give effect to agreements made by a series of email communications which followed very clearly the offer, counter-offer, and final acceptance approach under which the law determines that a contract has been made. It was therefore held that the email chain culminated and constituted an agreement in writing. In addition, the court held that the guarantee had been signed by the electronic signature of the persons who had sent the emails. Now, just for reference, this may not be the last we've heard of this case. The judgment I've talked about today was heard in the High Court Commercial Division. The case was heard subsequently on the 8th of November at the Court of Appeal, and the Royal Courts of Justice have stated that the judgment has been reserved and will be released within the next few months. Now, for judgment to be reserved is unusual and occurs in cases which are unusually technical or complex and difficult to pass a conclusive judgment, which suggests the result of this case may be subject to change or, at the very least, qualification. So we will have to wait with bated breath as to whether this decision is reversed or upheld. In the meantime, I can confirm that the recent case of WS Tankship 2 BV and the Kwangju Bank Limited and another, full reference is set out on this slide there for you, has affirmed and expanded the judgment from Golden Ocean. It was stated under this case obiter that a guarantee issued by a SWIFT message was in writing and signed by the party to be charged for the purpose of Section 4 of the Statute of Frauds 1677. In other words, the case reaffirms the position under Golden Ocean that a guarantee set out in email is in writing and is a binding contract. The guarantee under the Tankship case was deemed to be signed owing to the fact that the name of the guarantor appeared in the header of the email automatically as a result of sending the email. Therefore, the guarantee was said to be in writing and signed, and therefore enforceable. This case will be of particular significance in the finance sector, where it is now clear that guarantees issued via SWIFT will now be considered to be enforceable obligations. So, for the time being, caution should be adopted generally when negotiating contracts, and particularly when doing so via email. The Golden Ocean case has asserted that emails could constitute a legally binding contract, and indeed that it makes good commercial sense that they should do so. If you conduct your pre-contract negotiations via email and do not intend to be bound by them, and the email correspondence is simply a means of negotiating, denote the email as such by heading the correspondence as being subject to contract. Be sure that your conduct outside of emails also supports this statement. In other words, don't start performing obligations which will be captured under the contract, as such conduct could well be deemed to be indicative that a legally binding contract is in place, and the existence of a legally binding contract may be inferred by the court. In summary, subject to contract creates a strong presumption that the parties do not intend that a legally binding contract is in place, and whilst the presumption can be rebutted, it does at least afford some protection to pre-contractual negotiations and their status as such. And on that note, I am going to leave it here and hand you back over to Jonathan.